answers.
Justice Barrett.
I want to just ask a quick question about history. Justice Kagan was asking you about new scholarship that historians have identified, which you say shows that independent agencies has a longer pedigree than maybe some thought originally. But do you concede that the first statutory, anything that looks like a statutory removal restriction, like the inefficiency, neglect, malfeasance, appeared in 1887 with the ICC?
I don't know if it's the first, to be honest with you, Justice Barrett, I'm sorry. But what I would say is that as to the early commissions, I think that factor actually cuts the other way, because there was no provision authorizing presidential removal for some commissioners. That's our point. You had commissioners like the Chief Justice and the Vice President who were appointed by statute, and the President couldn't remove them under any circumstances.
But they were 2 of 5, and it could remove, he had unchallenged authority to remove the other 3 who served on that commission. I mean, and there's silence. I mean, there's not the inclusion of statutory removal restrictions. You didn't really see that until the ICC.
They were understood at the time to be, for the officers like the Chief Justice and the Vice President on the Sinking Fund Commission, for example, to be completely insulated from presidential removal. And it wouldn't make any sense for the President to be able to remove them from the commission. That was not the understanding at the time, as has been ably set out by many historians. But here's the bigger point, is that those commissions are in a lot of ways much more independent than modern day independent agencies. And petitioner's theory is based on the idea that any time these commissions are exercising significant governmental authority, every single commission member must be subject to at-will presidential removal. And in that respect, their theory cannot be squared with founding-era practice.
But counsel, the Sinking Fund had the Secretary of State, Treasury, and the AG, and there's no dispute, even under your theory, that the President could fire those 3. So sure, the Chief Justice and the Vice President, but he could very easily take control over the fund. Also, we distinguish that in Collins. I mean, it seems to me that these early examples had very, very limited authority. I mean, the Mint, or the Revolutionary War Debt Commission, there were no statutory removal restrictions, and all it did was settle accounts between the United States and individual states after the war. I mean, there's nothing that looks like the FTC at the time of Humphreys, or certainly not today. You have to concede at least that.
Yes, and two responses to that. I think it's a fair observation. But first, for the Sinking Fund Commission, for example, maybe it didn't wield the broad panoply of authorities of the FTC. That's fair enough. But Alexander Hamilton thought that it was absolutely indispensable to the health of the national economy, and that this was about managing the public debt, and he thought that it would implicate the nation's stability going forward. That's why they thought this governmental function should be vested in this multi-member commission. So it was not something that was deemed to be insignificant by any stretch of the imagination. But one more point on the difference between the 3 members and the 2 members. We have real-world evidence. This is not an abstract thing. We have real-world evidence of Chief Justice Jay, I believe it was, who could make the dispositive vote difference in terms of the Sinking Fund Commission of when they make a decision that the President's cabinet supports, when they make a decision that they don't. And so the fact that there are some members of the commission who were concededly not removable at will by the President, that just makes our point that the first President of the United States and the first Congress emphatically rejected the constitutional theory on which petitioner's position is predicated.
Counsel, let me say, let's say, just assume that I disagree with you about the history. Let's assume that I think, I'll grant you for this purpose that the decision of 1789, if you just took it in isolation, maybe not as conclusive as Myers thought it was. I'll just grant you that for purposes of this question. But let's say that I think the liquidation argument throughout the 19th century shows that by the time of the end of the 19th century, up until we get to the ICC, and the emergence of what starts to look like the more modern independent agency, that the government has the better of the argument. But let's say that in 1887, after the ICC, and then after the FTC, and then after Humphreys, when there was more of the explosion of independent agencies, that let's just assume, again, for this purpose, that at that point, yes, you do have precedents like Humphreys. Humphreys clearly is a good case for you. Do you still lose? If I think as of 1887, it was liquidated, it was settled, but then we did have cases and congressional practices that veered from that unbroken line?
No, we don't lose. We don't lose on the merits, and we certainly don't lose on stare decisis. So on the merits, the doctrine of constitutional liquidation by historical practice absolutely can apply based on the last 150 years of
But
history.
counsel, if it had the first, I mean, in the assumptions that I've asked you to make, it was liquidated as of 1887. So you think liquidation can kind of get a new restart, like kickstart in 1887?
That is not just my view. That is the view of this court in cases like, I believe, NLRB, Canning, and Chiafalo. And I would also direct the court's attention to United States versus Curtis Wright Export Corporation, where the court said, you have 150 years of historical practice. That's enough.
Okay.
Justice